Okay, so we will be dealing with widening and deepening as two important policies of European Union. Widening, as we stated, meaning enlargement. Widening and deepening has taken place through different stages or waves. Therefore, as far as widening is concerned, we will be, and we are speaking about different waves of enlargement or different stages of enlargement. Wave, dalga, genişleme dalgaları veya genişleme aşamaları diyoruz. As we have mentioned before, the European Union was found, or the European communities were founded by the 6 member states, which are called as the founding sixes. After it was founded, long after that, the first wave of enlargement included the United Kingdom, Ireland, and Denmark. It was in 1973. The first wave of enlargement of 1973 included the UK. UK includes which jurisdictions? When I say UK, you understand? England, Wales, Scotland, and Northern Ireland. When I say Great Britain, you understand? Without Northern Ireland. It includes England, Scotland, and Wales. Therefore, the UK, Denmark, and Ireland. When I say Ireland, then I mean the Republic of Ireland as another country. Then the second enlargement included Greece in 1981 and Portugal and Spain in 1986. Then came the third enlargement. It was in 1995, including Austria, Sweden, and Finland. What is Sweden in Turkish? Yes. Is Switzerland a member state of the EU? No. Is Norway a member state? No. In Norway, a referendum was held and it was rejected, the membership of the European Union. Therefore, Norway and Switzerland are not EU member states. In 1995, it was Austria, Finland, and Sweden. Then comes the largest enlargement of the European Union, the fourth enlargement in 2004. It included the Czech Republic, Hungary, Poland, Slovakia, Slovenia, Estonia, Latvia, Lithuania, Cyprus, and Malta. Shall I say it again? Yes. Okay, this is the largest enlargement of the European Union. It includes the Czech Republic, Poland, Hungary, Slovakia, Slovenia, Estonia, Latvia in Turkish? Lithuania? Exactly, Lithuania. Cyprus and Malta. When we say Cyprus, what do we understand? Do we understand South Cyprus or North Cyprus or the Republic of Cyprus?
South Cyprus.
We understand the Republic of Cyprus as an island, not only the southern Cyprus. In international, the international community understands Cyprus as a whole island, and the member of the European Union, the member state, is the Cyprus as a whole. However, in the Northern Cyprus, in the Turkish Republic of Northern Cyprus, EU law is not applied. Okay? It is written in the accession treaty of the Republic of Cyprus that in the northern part of the island, because of the situation, the practical situation, the EU law is not applicable at the moment. But the member state is the Cyprus as a whole, including the northern part. Yes?
The northern part is a member too, right?
Yes, yes, yes. No. As you know, because of this international political problem on Cyprus, for the Turkish side, there are two states in the island. We believe, as a national policy, that there are two countries there. For the other policy, for the Greek policy, to which international community also has adopted, is that there is only one country, the Republic of Cyprus, Turkish being the minority. Okay? And when the Cypriot Republic applied for EU membership, the EU accepted the whole island as a member state. All right? Yes.
If they accept it as a whole island, then why don't they apply it in the northern part as well?
It is
contradictory?
No. It is not the EU that applies EU law. It is the member states that apply EU law.
So if the northern part wanted to apply the EU law, they would be able to?
Exactly. But
They just don't want it because they are part of us.
No, they are not part of Turkey. They are another. The Northern Cyprus is a sovereign country itself. It is not part of Turkey.
I mean the nationalist feelings.
No. Still, they believe that there are two countries in the island. That is why they do not apply. They don't believe that the whole country has acceded to the European Union. Why there is such a provision in the accession treaty is that if the Cypriot Republic, for Turkey, it is the Southern Cyprus, does not apply European Union to the north in normal conditions, this would be infringement of EU law. So that would be a problem for that member state. But that member state says that I can't apply EU law to the north or in the north because of the situation. Because there is another, they say that there is the Turkish force in the north, that's why I can't enter and apply the law. This is the reason why they have put such a clear provision in the accession treaty. Otherwise, they would have been liable. Sorry?
So they prevented the penalty before?
They've prevented yes, you can negotiate such provisions in the accession treaties. It is obvious that the Southern Cypriot government cannot apply EU law in the north. Is that true?
Yes.
Of course. So how could you say that they infringe EU law every day? This is not possible. That's why they have put clear provision in the accession treaties saying that because of this de facto situation, EU law is not applied in the north. Okay?
So can we say that they do not recognize Northern Cyprus Republic as another state?
Of course, this is only Turkey recognizes.
Okay, so they just say that there is an area and there are people living in it.
As minority.
Yes, it's not an individual state.
They believe that there is one country on the island, and this is the Republic of Cyprus, and the Turkish minority is included there, within that country. All right? For Turkey, and for the Turkish Cypriot community, there are two countries on one island. One Turkish, one Cypriot.
But there is actually two states. Why they do not just accept it?
This is a very long story. The Cypriot problem has a background of decades. Therefore, it is not easy. It is one of the most important problems in the Turkish foreign policy as well. All right? Its membership was even very problematic for Turkey because we do not recognize that state as such as the Republic of Cyprus. We are a candidate state in the European Union, and they have applied and became a state, a member state in the European Union. This has been an important problem in the negotiations with or between EU and Turkey as well. All right? Yes. Any other questions? Yes.
The EU considers Northern Cyprus as an invasion.
Yes. So this was the most problematic enlargement of the European Union, not only because of the number of new member states, but also because that they have, or certain member states had social and political and economic problems. Normally, there is a homogeneity between the EU member states, but with these ones, first, there was a high number of member states, new member states, and second, there was no homogeneity in terms of their social, political, and economic situation. In 2007, it was Bulgaria and Romania which became EU member states. Then the last enlargement took place in 2013, including Croatia. Therefore, today, still, EU includes 28 member states. You wanted to ask something? Yes.
When was the fourth enlargement? I guess
2004, 2007. Okay. When or before the EU widens, it normally deepens as well, meaning before more or less every enlargement, the EU had to change its founding treaties as well to adjust itself to the newcomers. Deepening, therefore, is defined as changing and developing the structure of the European Union as well as its policies. Again, deepening takes place under different stages, and in every stage, as you will be seeing, there is an amending treaty, a treaty amending the founding treaties. Some of these stages are very important or have been very important in the EU's history, and some others had less importance. All right? We will now be speaking about the stages of deepening. The first stage of deepening in the founding in the European Union took place in 1965 by signing the merger treaty. The merger treaty was signed in 1965 and came into force in 1967. Merger treaty in Turkish, füzyon antlaşması veya füzyon olayı olarak bilinir. It was the first treaty that has changed the founding treaties, the original treaties of the European communities. The merger treaty merged the most important institutions of the three communities, the Council and the Commission. Before the merger treaty, there were three councils and three commissions for three European communities. So one commission for coal and steel community, one commission for Euratom, one commission for EEC, one council for ECSC, one council for Euratom, one council for EEC. All right? This treaty merged these institutions into one. So one commission became powerful for 3 communities. One council became powerful for 3 communities to prevent the duplication of work. To prevent the duplication of work, the councils and the commissions were merged into one. The second stage of deepening can be mentioned as budgetary treaties. The first budgetary treaty was signed in 1970 and came into force in 1971. And the second one was signed in 1975 and came into force in 1977. In both of them, I will be explaining very short. Please do read from the chapters I have left for you. The role of the European Parliament was increased in the budgetary process. In both of the treaties, the role or the power of the European Parliament was increased. The first one, the first budgetary treaty, gave the European Parliament the last word on non-compulsory expenditure. And the second budgetary treaty gave the Parliament the power to reject the budget as a whole. The second treaty also established the European Court of Auditors. The European Court of Auditors. The Court of Auditors in Turkish, the Court of Auditors, Sayıştay. The European Court of Auditors, Avrupa Sayıştayı. The first most important treaty amendment was the Single European Act. Single European Act in Turkish, Avrupa Tek Senedi. Avrupa Tek Senedi. It was signed in 1986 and came into force 1987. One question for you. Why does it take at least 1 year after signing the treaty to come into force? Yes? What's your name?
Cansu.
Cansu.
Because there's an adjusting process of the laws before and after the treaties.
Adjusting the national law?
The national and the law which was applied by the European Union.
No? Yes?
After signing the treaties, there's a process of giving consent, like onay.
How do we say it in English? Ratification. Ratification. What do we mean with ratification? A very important legal term we use very often. What would that mean? Yes, Deniz?
I mean, there are different processes in international public law. First, you sign it, but I mean, it concerns national law. Parliament, for example, I mean, whatever their rules are. For example, first we sign that as ministers, and then it should. I'm talking about Turkish process.
Is there where is it provided in Turkish law? Ratification of international agreements. It is in the Constitution, Article 90 of the Turkish Constitution provides for the procedure or provides for the international agreements to come into force. This procedure of incorporating international agreements in national law is known as the process of ratification. In EU law, there is no uniformity, I would say, to ratify the amending treaties. This means, what would that mean? This means that every member state ratifies the amending treaty
At its own pace.
exactly according to its own constitutional requirements. There is no uniform procedure for ratification. Therefore, in some states, it may require approval of the parliament. Sometimes it may require approval of the parliament plus approval of the president. And sometimes it requires referendum. We do not know, of course we know, but we do not know it by looking at the EU law. We know it by looking at the national laws of the member states. Therefore, it usually takes some time to ratify the amending treaties to incorporate it into its national legal system for the member states of the European Union. The Single European Act, therefore, was signed in 1986 and came into force in 1987. It was the first major revision of the treaties of Rome. The aim of the Single European Act was to complete the single market by December 1992 with more effective institutions and with more effective decision-making procedures. Therefore, although the aim of establishing a customs union existed in the treaties, in the EEC treaty, and although the customs union, Gümrük Birliği, was established in 1968, non-tariff barriers persisted, stayed. Therefore, the Single European Act also wanted to refresh this idea of establishing a single market. Do you remember that last time we spoke about an internal market, a common market, a single market? What do we need for that? To establish a common market, we need first a customs union. For customs union, what do we need? No. For customs union, what do we need? What are the requirements of a customs union? Yes?
It's a common external.
But before that, what do we need for customs union?
Free movement of goods.
So how do we provide for free movement of goods?
No duties.
Okay, we have prohibition of. Okay, we have, yes, prohibition of customs duties and charges having equivalent effect, meaning we need prohibition of tariff barriers. We need prohibition of non-tariff barriers, quantity restrictions. And third, we need a common external customs tariff. Now, until the Single European Act in 1968, customs union was established, but non-tariff barriers persisted, stayed. Can we speak about a real customs union with non-tariff barriers?
No.
No, we can't. Therefore, the Single European Act refreshed this idea of establishing a single market, and it provided certain important institutional changes as well. One of the very important changes is as regards the role of the European Parliament in legislative process. The role of the European Parliament in the legislative process. Previously, we have mentioned that today the European Parliament is a co-legislator with the Council, but it was not as such at the beginning. You will be reading that the European Parliament has evolved into a real legislator in the EU, but through time. It took some time. At the beginning, when the treaties of Rome were first adopted, the role of the European Parliament was limited to consultation only. Consultation. In Turkish? Exactly. At that time, the Council was the only legislator. The Parliament only had a consultative body, meaning that the Council had to ask for the opinion of the European Parliament before adopting the legislation, but it was not binding. The opinion of the Parliament was not binding. So at every treaty amendment, you will be reading, and we will be talking here, that the role of the European Parliament has increased to provide democratic legitimacy and to decrease democratic deficit in the EU. Deficit? Exactly. Democratic deficit? Demokrasi açığı. So the first increase in the legislative role of the Parliament was with Single European Act, which adopted the cooperation procedure. The cooperation procedure, in Turkish, işbirliği usulü. The cooperation procedure does not exist anymore today. It is abolished. It was abolished in 2009 by the Lisbon Treaty, but it applied between Single European Act and Lisbon. It increases the role of the European Parliament in legislative process, but it does not make the Parliament a real legislator. So, the cooperation procedure increases the role of the European Parliament in the legislative process, but it does not make the Parliament a real legislator. So what does it mean? It means that, Deniz, do you know what it means?
The European Parliament was able to block legislation, but they couldn't make legislation like those, as far as I know. They could block legislation which were...
Block veto, you mean? No? Yes? Block. What do you mean? Is it vetoing a decision? And what do you mean, something like that? Is it that or not? Is it...
Prevents, maybe.
How?
They power line.
Do you know how? How? Okay. No, Atakan?
I'm going to say the same thing.
What does it mean by them blocking?
Their vote is required in order to legislate the law, but they cannot make a suggestion in a law to legislate in the first place.
No. No. Normally, the Council would act by qualified majority. Okay? Therefore, if the Parliament has a positive opinion on the proposal, the Council would adopt the legislative instrument by qualified majority. But if the Parliament has a negative opinion, then the Council has to find unanimity. Therefore, if there is a negative opinion of the Parliament, the Council can no more adopt the act by qualified majority. Therefore, the cooperation procedure forces the Council to act by unanimity if there is a negative vote of the European Parliament. But it does not make the Parliament a real legislator. Okay? The Parliament may put the Council into a difficult position because now it has to find unanimity. Okay? But it does not make the Parliament a real legislator. In the Single European Act, other than the cooperation procedure, also the assent procedure was adopted. This is another legislative procedure in EU law. Today it is known as the consent procedure. Its name is changed by the Treaty of Lisbon. And it gives the Parliament the power to veto the accession of new member states, and the adoption of international agreements. The procedure is applied in very limited areas, but in very important areas. Therefore, once the Parliament vetoes, then the procedure is finished. Another institutional change is that the Single European Act established the European Court of First Instance. The European Court of First Instance. In Turkish, yes, ilk derece mahkemesi. Avrupa ilk derece mahkemesi. The European Court of First Instance. This is the second court in the European communities, the first one being the Court of Justice. This is the second one. Today its name is changed to General Court. Genel Mahkeme today. Another important change is that the meetings of the heads of state or government, was formalized as the European Council. There are other changes brought by Single European Act, like increasing the areas subject to qualified majority voting. Please read, all right, from the chapter I've left for you. Not possible to deal with every change brought by every treaty amendment. Yes?
Sorry, I missed the veto. The veto to the accession of the new members?
Exactly, and the adoption of international agreements. The next treaty amendment was one of the most important amendments in the EU's history that took place in 1992. The treaty was signed in 1992 and came into force in 1993. It was the Treaty of Maastricht, or the Maastricht Treaty. The Treaty of Maastricht, or the Maastricht Treaty. In Turkish, Maastricht Antlaşması. The Maastricht Treaty established the European Union for the first time under a three-pillar structure. Therefore, technically, it is not possible to speak about the European Union before 1993, because for the first time, it was the Treaty of Maastricht that established the European Union. Before Maastricht, we spoke about European communities and not European Union. The three-pillar structure in Turkish? Sorry? No? The three-pillar structure, üç sütunlu yapı. Avrupa Birliği'nin üç sütunlu yapısı. It is composed of three pillars. The first pillar is economic integration pillar. Or the communities pillar. In Turkish, ekonomik entegrasyon sütunu veya topluluklar sütunu. This structure as a whole is the EU. The first pillar is economic integration pillar, whereas the second and third pillars are the political integration pillars. Therefore, since Maastricht, the European Union is not anymore an attempt for economic integration, but also political integration. As the first pillar of the European Union, the communities pillar included three European communities, which are the European Coal and Steel Community, Euratom, and EEC. It included the three European communities. This was the supranational pillar of the European Union. It was the supranational pillar of the European Union, and the binding instruments of EU law were mainly subject to qualified majority voting. Therefore, mostly in the policies of the first pillar, the instruments were adopted by qualified majority voting. Again, as the supranational pillar of the European Union, the supranational institutions had more powers. They were more powerful in the first pillar of the EU. What are the supranational institutions of the EU? The Parliament and the Commission. In the first pillar again, the Court of Justice had full jurisdiction in the first pillar. The Court of Justice had full jurisdiction. Jurisdiction in Turkish? Okay. The second pillar and the third pillar were political integration pillars, as we said, or intergovernmental pillars. Not supranational, but intergovernmental or international. Intergovernmental in Turkish? Hükümetler arası. This means that in the second pillar, there was a minimal role. The second pillar is named as Common Foreign and Security Policy Pillar. The Common Foreign and Security Policy Pillar in Turkish, ortak, dış ve güvenlik politikası. Common Foreign and Security Policy. the European Parliament and the European Commission had minimal role in this pillar. The European Court of Justice had no role, and the decisions are mostly taken by unanimity. It is more like an international organization, not like the EU being supranational. But the second pillar was mostly, because it has got intergovernmental characteristics, the member states acted more like in an international organization. Third pillar, bravo, the cooperation in justice and home affairs. In Turkish, adalet ve iç işlerinde işbirliği sütunu. This was also an international intergovernmental pillar, a political pillar. It included cooperation on asylum. Asylum? Sorry? İltica. Immigration. Göç. The third country nationals and international crime. Third country nationals. Üçüncü ülke vatandaşları. In this pillar, there was limited role for the Parliament and the Commission. There was no role for the European Court of Justice. The Council usually acted by unanimity. The two pillars, the second and third pillars of the European Union, aimed mostly to establish a cooperation between the member states rather than the adoption of legally binding rules. So there was a loose cooperation or integration, we could say. The EU, the member states, acted more like international organizations. The Council had important powers. They met in the European Council like an international organization, all right? Not like the European Union. Therefore, this was the most important change brought by the Maastricht Treaty. Secondly, the treaty changed the name of the EEC, European Economic Community, to EC. So after Maastricht, including the origins of the EU, we have heard about European Economic Community, we heard about European Community, we heard about European Communities, and we heard about European Union. Too many things which sound very close to each other. That is why the Lisbon Treaty changed all these definitions, as you will be seeing, all right? But it became too many European communities, European community, European Union. Another change was about the role of the European Parliament. The Maastricht Treaty, for the first time, provided the European Parliament as a real legislator with the Council of Ministers by adopting the co-decision procedure. Co-decision procedure. In Turkish, ortak karar usulü. Under the co-decision procedure, the Council and the Parliament, for the first time, acted together to adopt a piece of legislation. If Parliament does not give an approval, the Council cannot adopt it by itself. If the Council adopts it by itself, the Parliament again cannot do anything by itself. Therefore, they act as co-legislators. Today, the name of the co-decision procedure is changed to the ordinary legislative procedure. This change was made by the Treaty of Lisbon in 2009. All right, any questions? No questions? Okay, so I see you on Wednesday.